Today, we are going to be discussing the federal habeas corpus petition that was filed by Marty Weinberg on behalf of Karen Reed. Now, we're not going to be reading the entire 31 pages to you. A lot of it is information and facts and case law that you already know. Definitely been following this channel, you know. And really, he just attacks the SJC opinion, which we already levied a number of attacks ourselves if you've been following the channel. And it's very similar to the same analysis that I ran through with the SJC opinion. So he's got some issues with this with the SJC opinion. There are definitely some issues there with their analysis. It's not the greatest. But the question really is, how is he able to even go to the federal courts? You know, after all, this is a state case. These are state crimes. She was tried in state court. He already appealed it to the highest state court, the Massachusetts Supreme Judicial Court. So how come now he can go to the federal system? Well, the answer to that is that since this is a federal issue, double jeopardy is, after all, an amendment to the Constitution. So it's in the federal system. So after he's exhausted the state courts, now we can go to the federal courts and get their guidance and their opinions about this matter. Now, I will say that I believe that her chances are actually better in the federal system. And that is because it seems from my research that the federal cases and the federal rules actually require a lot more of a judge before there is a declaration of a mistrial. And when you use Massachusetts state cases to interpret some of the federal regulations, a little bit different. And it was a little bit more lax, shall we say. Now, so this is just aside from the point. So just for all you free Karen readers, I mean, this is a better chance that she actually may get this appeal granted, and they may find that there's double jeopardy in this case. So before we jump into the federal habeas corpus petition, I want to revisit what we discussed yesterday, and that was that there was this hearing, and in the middle of the hearing, Judge Cannoni left the bench, came back huffing and puffing, out of breath, and suspended the hearing for the day, told everybody we're going to come back in another week, and all parties, affected parties, can be more prepared, meaning they should lawyer up, and we're going to have a continuance on that hearing next week. So there's a lot of speculation, a lot of allegations that are going around what exactly is happening. So we tried to explain this in yesterday's video. And really, to me, it seems that the person who's really should be the most concerned about this is Alan Jackson, not really so much Karen Reed. Now, Karen Reed, of course, wants Alan Jackson as her attorney. He's a very good attorney, and he was great. He did a good job. He really knows what he's doing. So she definitely wants him there. But it's not like if they're missing Alan Jackson that, you know, she's going to be in a terrible place. She's going to have a lot of other very, very good attorneys to represent her for this case. So really, the issue more is Alan Jackson specifically. Did he misrepresent something to the court? Did he tell the court something that was not true? You know, and then the other question is, did he not fulfill his Rule 14 obligations, and what exactly is that going to mean for the Arca experts? So in terms of Alan Jackson himself, as we discussed, that's his issue. So the question is, you know, hopefully we'll get some more clarity. It wasn't so clear from yesterday's hearing. We heard some things from Hank Brennan, and then it was unclear which documents he get from who, what did he get from the federal government, what did he get turned over from the defense. At the end, he said, well, the defense turned over all these documents. So what documents did he get from the from the FBI? It wasn't 100% clear. So that's going to be important. And also what dates he got what specific documents. You know, so for example, this $23,000 bill or $22,000 bill, you know, if that was just a recent bill that was submitted by Arca because the defense hired them and retained them, so there's no smoking gun there. I mean, that's what these experts cost. And if the defense turned it over, so then there's no Rule 14 obligation that they didn't fulfill. So, you know, all these questions that we have, that's going to be addressed next week. You know, and that's why I think that really the more important issue here is Alan Jackson specifically himself. That's really the question. Whether he misrepresented something to the court, that's going to have to be cleared up next week. But in terms of Karen Reed and in terms of the Arca experts, so let's talk about that. So is there anything that I saw from yesterday that would mean that the Arca experts should be precluded? No, I didn't really see anything that the Arca experts should therefore be precluded or excluded for any reason. Now, you know, now that Hank Brennan has the information, there's still 6 weeks before trial. So what prejudice is there really? You know, so you know, what type of remedy or sanction should Judge Cannoni impose? It's not so clear. You know, so in terms of the Arca experts testifying, like I've said yesterday, the Arca experts should testify. That is the correct ruling. Now, Hank Brennan may want to exclude them for other reasons. Maybe he's going to try to exclude them because there's some other information that the federal government is not turning over that he's entitled to under Rule 14. And even though the defense cannot provide them or produce them, but at the end of the day, if it's not produced, then it's a violation. So he can argue, therefore, the Arca experts should not testify. Now, good money would say that she's going to allow the Arca experts to testify because you still have 6 weeks to trial, and anything that happened in last trial is last trial. So maybe you want to sanction Alan Jackson, and you know that's your own personal issue with Alan Jackson. But in terms of this upcoming trial, what prejudice is there really to the Commonwealth that they can't have the Arca? It's not fair to have the Arca experts testifying at this point. So the right decision here is to allow the Arca experts to testify. If whatever reason she decides the Arca experts should not testify, so it depends. If it's because some other novel argument that Hank Brennan comes up with, and nothing that anybody did wrong, so then it's going to be it could be reviewed for an abuse of discretion, and it could be very well, since these Arca experts are integral to the Karen Reed's defense, it could be very well an abuse of discretion not to allow them to testify. So and if you don't allow them to testify based on some conduct of Alan Jackson, that's what I was saying, that if that's what she's pointing at, that because the attorney acted in a certain way, and you can point to the attorney's wrongdoing, then you can have an argument for ineffective assistance of counsel. So you're giving Karen Reed that option. So the right decision here is to allow the Arca experts to testify. That is just simply the right decision at this juncture from what we've seen up until now. There's still 6 weeks to the trial. They can turn over all documents that they want now. They can give them everything, and there's no prejudice. Now, let's talk about if the Arca experts actually testify. So then now, has their cover been blown? And they're not really objective. They're really just working in coordination with the defense, and they're biased. Is that going to be an argument that can be taken seriously? So here's my opinion on that. It has not been shown at all, from what I've seen, that the Arca experts were working with the defense or had any sort of interaction, any sort of communication, any sort of coordination when they were actually doing the reconstruction. When they did the reconstruction, when they wrote the reports, they were 100% objective. They were insulated from the defense and the Commonwealth. They had nothing to do with them. If afterwards they reach out to the Commonwealth or the defense and say, look, we did this work for somebody else. This is our work. These are our findings. You're both welcome to hire us. And the defense says, okay, sure, we'll hire you. And then we have to pay you all this $22,000 because they're expensive and they're extremely qualified. Well, then what's the argument going to be to the jury? Ladies and gentlemen, you shouldn't believe these Arca experts because they're not really objective. Why not? Because they're getting paid by the defense. Well, did the defense pay them to actually do the reconstruction? Or did the defense just pay them after they already performed the reconstruction and wrote the reports and came to their opinions and conclusions for an independent body that had no interest in this case? And now, just because we want to use them and have to pay them for the time, we have to pay them this money. And if you contrast that with the Commonwealth's expert, who everybody keeps talking about, this reconstruction expert, so we don't know exactly what he's going to say, but let's say he does say that somehow it's consistent, the damage to the vehicle and the injuries to John O'Keefe. Well, there you can say very clearly, the Commonwealth actually hired this person to do the reconstruction. So they were already in communications. They knew exactly what they wanted their expert to say. The expert knew exactly what the Commonwealth wanted him to conclude. And what do you know? That's what he concluded. So if you can still, we're at a position where if you contrast the Arca experts versus this Commonwealth's expert, they're still much more independent. The Arca experts are still much more independent and objective than this other Commonwealth's expert is going to be. So they can try to make that argument still, like the fact that this $23,000, which most likely, again, this is again speculation, and I'm assuming that this bill was incurred for the second trial when the federal contract ended and the defense had to hire them. So yes, you have to pay experts. Like that's just the real world. So that's probably what this $23,000 was. So yeah, they can point that out. They can say, yeah, I mean, you're paying these people all this money to come testify. You're right. We're paying them for the time, but we didn't pay them to do this reconstruction. We had no interaction with them. We had no influence over them when they actually did this reconstruction, which is just the opposite when it comes to the Commonwealth expert in this case. So still, if it's a battle of the experts, you have to tilt right now, as it stands right now, you have to tilt in favor of the Arca experts. Okay, so that's as it relates to the Arca experts. Now let's get into the federal habeas corpus petition that was filed by Marty Weinberg. And we're only going to be discussing one part of it. I'm not going to read for you the entire 31 pages. And a lot of it, like you know already, all the law and the facts behind all this. And if you see my videos, you know the issues that I have with the issue with the SJC's opinion. But I want to talk about one part of this, which a lot of people still are confused about, and they still have a very big misunderstanding about. And it seems that Marty Weinberg is included in that. Now people are going to attack me. Oh, you know better than Marty Weinberg. I'm just going to talk to you from a rational, reasonable position. You can make your own conclusions. I'm going to tell you what my research has shown me. I'm going to share that with you. Okay, so here is the part that I'm going to talk about. I'm jumping all the way to the end. Isn't that great? Conclusion. For all the foregoing reasons, the defense respectfully requests that this court issue a writ of habeas corpus and hold that Ms. Reed's retrial on counts 1 and 3 would violate her double jeopardy rights. So what's he asking for? That counts 1 and counts 3 should be dismissed, but not counts 2. Not count 2. Count 2, no problem. You can retry her on count 2. Now, why is that a problem? Why do I disagree with that? And why is it a tremendous misunderstanding of the law? Here we go. There's two different arguments that are made in this case. Okay, we've been talking about this a lot, but there's two different arguments that double jeopardy should attach. The first argument, which is not as exciting and not as meritorious, we're going to talk about, but this is still brought up in Marty Weinberg's brief. And that is the argument that really the jurors really acquitted Karen Reed on count 1 and counts 3. Now, the acquittal wasn't in open court, and it was only a few weeks after that we got the jurors together and they all agreed, let's say, even though we didn't get all the jurors together, but let's just say that we could get all the jurors together and they can all agree that they acquitted her on counts 1 and counts 3. So therefore, that's really an acquittal. That's really an acquittal on counts 1 and counts 3. And therefore, textbook double jeopardy tells you that you can't be charged again, can't be tried again on charges 1 and charges 3 because there was an acquittal. Okay. Now, as I explained already many times, that argument is going nowhere in a hurry. Okay, because we only allow verdicts to be reported in open court. That's clear. That was like that. That's not an issue of contention. Now, there are certain cases where we bring jurors back, and those cases are when there's racial and ethnic bias that are injected into deliberations and jury tampering. Those are the only situations at all where you ever find any sort of case that allows you, any sort of opinion that allows you to bring the jurors back and ask them really what their verdicts were. Okay, but absent that, we are not opening up this can of worms and allowing jurors to come back a few weeks afterwards to report their verdicts. Now, I know it's not fair. Doesn't seem fair to Karen Reed, and it's not fair. But they're not going to make an exception just for Karen Reed because they have to work with rules. Once they make an exception for Karen Reed, then they're opening up a whole new area which could be abused. And then a lot of people who really are guilty, can be trying to exploit that. So that's not happening, and the law does not favor this. So that argument is going nowhere, like I've explained from the beginning. The other argument, which is more interesting. Now, let's just finish off with that argument. Now, if that's the only argument that you have, then it makes sense to only ask for double jeopardy to attach to counts 1 and counts 3. Because your argument is that there's an acquittal on counts 1 and counts 3, and there was no acquittal on count 2. And if that's what your argument is limited to, so then yes, you're asking the court to find that there's double jeopardy attaches to count 1 and count 3. Okay, if that's what your argument is limited to. But you don't want to limit your argument to that argument because that's not a great argument. And that's a loser of an argument, like we've explained from the beginning. The more interesting argument, and the argument that has actually more teeth, definitely in the federal system, is the fact that the mistrial in this case was improper. The declaration of a mistrial was improper because you have to follow certain rules in order to declare a mistrial. One of them is that you have to find, let's say, that there's manifest necessity. Let's just analyze this under manifest necessity because everybody loves to analyze it under manifest necessity. Manifest necessity requires two things. Okay. Number one, that counsel was given full opportunity to be heard. Number two is that the judge carefully considered alternatives on the record. And definitely in the federal case, they're much more strict on the judges with this. The judges have to be much more careful and actively giving opportunity for counsel to voice their opinions and giving full opportunity to be heard, as well as explore alternatives on the record. Okay, that wasn't done in this case. That was not done in the Karen Reed case. So, like I keep saying, the federal, you may have a better argument here. Now, let's talk about that. Okay, let's talk about the fact that a declaration of a mistrial was improper. And that's the much stronger of an argument in the Karen Reed case. If you're going to argue that, then you have to ask yourself, okay, is that also only limited to charge 1 and charge 3? Which would mean that when Judge Cannoni was making a declaration of a mistrial, she only made the declaration of a mistrial, which was a mistake, on charges 1 and charges 3. Now, if you analyze it using the fact that she did not give counsel full opportunity to be heard, and the fact that she did not give reasonable alternatives, if that is true, well, then that also applies to all the charges. Did she give opportunity to be heard on charge 2? Did she give alternatives for charge 2? No. And people I keep convoluting and mixing up. Well, the jurors came back and said that they were only hung on charge 2, so therefore, really the mistrial was appropriate for charge 2. No. We are ignoring what jurors say afterwards, because that's by and large what the courts do. We ignore the jurors after they leave the jury room unless there's racial ethnic bias or jury tampering. Otherwise, we are deaf to their concerns. So therefore, what we're left with, if we're completely ignoring the jurors, which is what we're required to do under the law, and when we analyze this under manifest necessity, so then you just look at what happened in court and you look at the declaration of the mistrial and what it governed. What did it govern? Which of the charges did the declaration of mistrial govern? Charges 1, charges 2, and charges 3. If Judge Cannoni would only say, we're only declaring a mistrial on count 1, but not on 2 and 3. Okay, well, then you can't make an argument that the declaration of mistrial was inappropriate or improper on charges 2 and charges 3. But she declared a mistrial on all the charges. And she did that, the argument goes, without giving counsel a full opportunity to be heard, definitely not actively giving them full opportunity to be heard, and also not carefully considering reasonable alternatives. So the argument here is that the declaration of a mistrial was improper as it relates to all the charges, not just charges 1 and charges 3. The only reason why you would keep mixing up charges 1 and charges 3 into your analysis of a mistrial being declared inappropriately is if you keep mixing up that other argument, which is not a good argument, which is a garbage argument, which is not a meritorious argument, and for the declaration of mistrial is not even a consideration. You don't find any courts, any opinions that when they're analyzing the declaration of a mistrial, whether it's inappropriate or not, you don't hear them talking about what the jurors reported afterwards, because it doesn't make a difference. But the analysis is limited to what did the judge do before she declared the mistrial? Did the judge give full opportunity to be heard? And did the judge give careful consideration to reasonable alternatives? And then if she did not, or he did not, then whatever that declaration of a mistrial governed, anything that it applied to, double jeopardy attaches. That's what the case law says. And there is no case, not one case that I was able to find, that you have a situation where the declaration of mistrial only applied to some of the charges and not some of the other charges, and they were found that double jeopardy only attaches to some of them, meaning that the declaration of mistrial was on all the charges, and the appeal in the appeal courts, or in the Supreme Court, in the federal courts, whatever, that they came back and said, even though the declaration of mistrial was on all the charges, your argument's only going to work for charge 1 and charge 3. It never happened. There's no case that I found. And if all your legal scholars out there want to do some research, go ahead. Show me the case, definitely in the First Circuit, where you have a declaration of a mistrial on the entire case, on all the charges. And then because of arguments that the mistrial was inappropriate or improper, that the judge, the courts ruled that double jeopardy will attach, but it will only attach to some of the charges and not all the charges. I did not find that case in the First Circuit. Now, I did find, just for completeness sake, I did find one case which is completely different than this case. Absolutely 100% different, which is where the jury actually came back with a verdict on one charge and did not have a verdict on the other charge. And the judge declared a mistrial on both charges. There was some discussion about this idea then. That's obviously not what happened here. What happened here is that from what we understood in court, what Judge Cannoni understood, what Judge Cannoni understood from court, is that they were hung on all the charges. If they were hung on all the charges, that means that the mistrial was on all the charges. If the mistrial is on all the charges, and you find that she did not carefully consider other alternatives, and give full opportunity of counsel to be heard, then her declaration of mistrial on all charges was improper. That's what has to be argued in this case. Okay, so that is the mistake. I think a lot of people are making it. Apparently, Marty Weinberg also made the mistake, and I can understand why it's made, but this is really the analysis. And if you want to find me a case, go ahead. Find me a case that where there's a declaration of a mistrial on all the charges, but double jeopardy only attached to some of the charges. Okay, that's all your homework. If you can find that case, then I'll definitely take back my opinion if it's actually similar to the Karen Reed case. I told you I found one case, which is not in the First Circuit, by the way, so it's not really, I have binding authority over this case, and it had nothing to, it was so different, so factually different from this that it doesn't apply at all. So that's what it really comes down to. That's why if you're able to in the federal court system to amend your writ, amend your memorandum, and ask for a double jeopardy attached on all charges, that is what Marty Weinberg should do. Okay, so that is going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.